Hello, everyone, and thank you for attending today's webinar sponsored by the Employment Law Alliance. My name is Peter Waltz. I'm the Chief Operating Officer at the ELA. For those not familiar with the ELA, we're the world's largest network of labor and employment lawyers with members in more than 100 countries, all Canadian provinces, and all 50 U.S. states. Our members work together to provide seamless, consistent legal advice wherever the need arises. We use webinars and programs like this one to provide practical information to our collective clients around the world, and we welcome you. We invite you to register on our website, which is ela.law. On the website, you can register for on-demand webinars, look at upcoming events, or access the ELA's exclusive Global Employer Handbook. This valuable tool provides labor and employment information for each of our 172 jurisdictions around the globe. Now for a quick overview of the Zoom webinar platform we're using today. Most of you know Zoom. We use it quite frequently, but there are a few differences in this program. So here's a just quick review for you. We are in listen-only mode today. In order to communicate with our panelists, please use the Q&A feature, which can be accessed from the Zoom menu at the bottom of your screen. To ask a question or simply make a comment, just click on the Q&A icon. It'll bring up that window. Type in your question and press send. If you have a specific question for a speaker, we ask that you list the speaker's first name, followed by your question in that box. That way our moderator can direct the question to the appropriate person. With such a large audience, we'll do our best to answer as many questions as we can live on the program. Our moderator will group similar questions rather, given the time we have. So submit your questions as soon as you'd like. And if we don't have an opportunity to address your question live on the program, we welcome you to reach out to each of our speakers following the webcast. A copy of the slide deck, as well as other resources provided by our speakers, are available on the website, the one you registered on. A link to this is in your registration email, will also be provided to all attendees during this presentation. Consider closing any unnecessary browser tabs, but if you do fall behind, you can refresh your screen. Press F5 with a PC or Command R if you're on a Mac. If you have any additional questions or you need assistance, just reach out to us in the Q&A box using the topic technical difficulties, and our webinar team will answer you in the background. The program is being recorded, and on-demand version will be available within the next 2 days. Today's going to be a very interesting program. We will have one of our seasoned moderators and a longtime ELA member moderating the discussion. So with that, I'd like to introduce our host and moderator for the event, Dale Stackhouse, who's a partner at our firm in Indiana, Ice Miller. And Dale, we have a great audience today. The program's all yours. You need to unmute, Dale. Still on mute.
There we go.
Yep.
Good morning, good afternoon, everyone. Welcome to our program today. We have a terrific group of panelists who have a variety of expertise that will be applicable to the scenarios that we're going to talk about today. Before I introduce them, I want to give you an overview of the kinds of topics we're going to talk about today. It is often the case when people get ready to move an employee overseas or bring an employee from overseas or hire someone overseas that they focus on immigration or visa and logistics issues. That is a critical part of this process. And we have one of our panelists today, Mary Snyder, who's head of the immigration group at Crow and Dunleavy in Oklahoma, who will talk about that part of the process. But we're also going to talk about several of the other issues that come up when you talk about moving employees overseas, including corporate presence creation, employee benefit issues, employment laws, tax issues, as well as decisions that you need to make about setting up and at some point in the future, maybe dissolving a local entity to serve at that as that employee's employer. We will answer a number of questions today, but we will raise even more questions. And one of the things that you should take away from this panel is knowing that while the answers vary the questions are often the same. And when you get ready to move someone, you should have on your issues list immigration, tax, corporate issues, employee benefits, and labor and employment. And think through all of those for each situation. Our panelists today include Walter Keiniger. Walter is a partner in the tax group at Marval, and Mairal in Argentina. Walter will be commenting from time to time today, both on the tax issues that these situations raise, and he will also serve as one of our experts on non-US law, giving us some color on other aspects of what a international employment arrangement with Argentina would involve. Chris Hall is a managing director at Global Tax Network. He's out of Connecticut. That is a tax advisory firm, and they do a lot of work with employers and employees and individuals who are working outside of their home jurisdictions, particularly tax return filing, but also compliance issues related to the obligations of employers. Nicole Forbes is Deputy General Counsel at Globalization Partners. Globalization Partners is a organization that will serve as an employer for you in jurisdictions where you don't have your own subsidiary or affiliate. And then Mary, who I've already introduced, will be serving as our immigration advisor and expert. The structure of the presentation we want to do today is to give you 4 scenarios that involve a number of questions that come up, questions that may be familiar or at least may be reflective of the kind of questions you may get from the people that you advise. And those questions and sample scenarios will cover questions like the right and wrong way to cover cross-border work. We've got some examples. We're going to talk about how to get, identify, and use the visas that you need appropriately. We're going to have some tax discussions, and then at the end, we'll have some open discussion and questions. So let's start with this one. In our first example, we have a client or an employer who's an Indian housewares manufacturer, and they want to set up an office in Toronto to explore the Canadian market. This Indian housewares manufacturer met a woman at a French trade show who is a Canadian citizen, and she knows the Canadian market well because she used to be a buyer for a Canadian department store chain. Her parents were raised in India, and the Indian company thinks she would be a perfect fit for their needs. She will be able to, she knows the housewares market. She's already in Canada, so they don't need to get her a Canadian visa. And she has a sense of what Canadian customers, including Indians living in Canada, would be interested in. Mary, would you like to, no, I'm sorry, Nicole, would you like to talk to us about some options we have for this kind of situation? Let's suppose that the Indian manufacturer called you and said, Nicole, how do we do this?
Thank you, Dale. So there are a lot of options here, and each option has benefits and each option has risks, certainly some of them much more risky than others. And the risk really needs to be weighed against the company's risk profile, but also examining what exactly this individual or the operations in Canada are going to be doing. So there's sort of a scale of operations. One of the first options is to set up a subsidiary to employ her. This often is the most compliant. It certainly also takes the most time and money as well. In setting up a subsidiary to employ her, you need to think about corporate form. Which kind of entity are you going to set up, or are you going to do a branch office? Capitalization requirements. Many countries require various capitalization requirements that range from, very little, €1, $1, up to, 25,000 euros or hundreds of thousands of euros or dollars as well. You need to also consider and look into whether you will need a local director in that country. In some countries, you need a local director, and so that can sort of stall setting up an entity. You need to also open a bank account, and in some countries, you need to open an actual office space in order to be able to have operations in country. So
Nicole,
those are
let me interrupt. Why not just employer? Just say, okay, you're in Canada, and the Indian company says you're an employee. What problems could that raise?
So this is a mistake that comes up often as someone goes into another country and the headquarters says, this is fine. We're going to continue the employment relationship. They've got, an Indian employment contract and things will be just great.
Sure, she's in Canada. She doesn't need a visa to be and work in Canada, right?
Yeah. The issue with that is that the local employment laws apply where the worker is generally performing work. And so once this worker sort of goes to Canada and starts working for the company in Canada, she's governed by Canadian employment laws. And then if you think about provincially what province she's in, there's going to be another assessment about which province laws apply to this individual as well. And from the corporate perspective, by setting up operations in a new country, you may be opening yourself up to what's known as permanent establishment risk, where the country that you are operating in sort of says to you as a company, you've been operating in our country, please pay us all the corporate taxes and also payroll taxes and employment taxes. So really this employee, if she's living and working in Canada, needs to be a Canadian employee, needs to be enrolled in all the Canadian social systems. You need to be running payroll from Canada and paying into the Canadian just social security systems and all of that. So it seems like an easy thing to just say, well, let's just have her move and it'll all be fine, but that's not quite how it goes.
So why not just make her an independent contractor? Then we don't have to worry about any of that stuff, right?
Good question. Independent contractors are generally quick, and you think it's the most sort of cost-effective situation, but there is a lot of hidden, I would say, tax and employment costs. And the laws around independent contractors don't necessarily self-execute. So it's not a problem until it really becomes a problem. The first thing that you want to think about is whether she really would be sort of a bona fide independent contractor. And you're going to need to look at the sort of tests set out under Canadian law about whether she would be an independent contractor. Most countries have a baseline sort of approach to employment that workers are generally considered employees, and you look at a lot of different factors. So you're going to want to look at subject to control and direction. Is the company going to be telling her how to work, where to work, what to do, time, all of that type of thing? Is she going to work full time for this company and have no other clients? Is the work that she's going to be doing really integral to the company? And is the company going to want to provide her some sort of benefits? If you're answering yes to any of those questions, most likely she's really going to be considered an employee, and you run the risk of a misclassification claim. And that can get expensive very quickly because the authorities take what you pay as an independent contractor as net salary, and then they assess on top, okay, now you owe us for employee payroll deductions. You also owe us for the employer contributions. These can sometimes open into an investigation where then you're looking at needing to pay taxes from a corporate presence. And so while it seems like a quick and easy solution, the costs for an independent contractor when it goes wrong can actually be quite high.
Okay. And I see Chris nodding. Chris, I think you're indicating that this is true not just in the US and Canada, but probably the same kinds of risks exist in other countries as well.
Yeah, absolutely. I mean, to Nicole's point there, about the nature of testing for employees, that's, a very strong issue in Europe, UK also, even though they decided to leave Europe, and very similar views about this. The tests are very similar around the world: direction of control, financial risk. All of those are very common factors that we see and are increasingly under inspection. And I think that will only grow with this move towards a remote workforce.
I think that's right. And that's been my experience in various countries too, that many things change, but the basic tests are often similar. So Nicole, how about option 3? What if I avoid treating her as an individual, and we just say, we like you, we think you got a lot of potential, we like this relationship. How about if you set up your own company, then we'll enter into a consulting agreement or a services agreement with your company. And then you can worry about all of that employer-employee stuff. Does that work?
It sounds great, but it doesn't always work. These are similar flavors of the independent contractor sort of issue as well. And so again, the authorities in a particular country are going, and the legal systems are going to look at substance over form. So really, what is this individual doing? What is, what kind of direction and control the company is exerting over her? And unfortunately, just setting up your own company, having her set up her own company and then contracting with that company doesn't get you around the liability scenario. And in some countries where we've seen in the UK, for example, where they've recently enacted IR 35, it used to be the case that you could contract with these individual companies and place the classification burden, or the burden of getting it wrong, essentially on that company, the personal services company. But their laws have now been revised such that the ultimate end user of the services, which would be the company in this case, is really going to be the person bearing the risk of any misclassification claims and for getting it wrong. And so we're now sort of seeing a lot of jurisdictions enacting laws that this doesn't get you out of the liability from a misclassification claim. And that's sort of the same with the independent distributor or agent as well. Certainly there are certain benefits to these kinds of arrangements depending on what the individual was doing, and also how much control the company wants over this person, whether they want to have direct interaction with customers or not. These I sort of all group in the independent contractor sort of bucket, and there certainly are a lot of risks with going down that path.
Okay, but you're not telling us that every single international distribution agreement is at risk of being an employment
No,
rate, right?
Definitely
If I've got a company in the UK and they have 12 employees and they distribute things for all kinds of other suppliers, and I'm just one of theirs, that's pretty low risk, isn't it?
It generally can be, yeah. So it really depends on the facts and situations of each case, but there certainly are arrangements where you really will have a bona fide distributor arrangement or agency arrangement, or even independent contractor. I mean, if you're going to engage someone short-term for a very specific project, and they really have sort of the freedom and control to complete the work as they see fit, you can fit within these other buckets where it does make sense and is low risk to enter into one of these other arrangements.
Well, that's what we tell people. If you're going to have an independent contractor and you think you really meet the standards, you should put a bunch of self-serving language in there reciting all of the factors you're aware of and how you meet them all, even if it seems unnecessary for purposes of recording the relationship between the two parties. That means your contract says things like, this person can work for others, even though they're also working for us. This person shall supply their own cell phone and their own computer, etc., and recite them all. So tell us about option 5, which is often the best one.
Option 5 is often the best one. I will mention on the independent contractor route that if you do go these other routes of independent contractors or distributor agencies, one of the things you really want to make sure, depending on what the individual is doing, is to protect your intellectual property rights under an employment relationship. Often intellectual property is directly assigned to the employer. In these other relationships, it's not. So you really want to make sure this individual is, if they're creating any intellectual property or works, that it's being directly assigned to the company.
Good.
On to 5. So the employer of record solution is a great sort of another option that allows companies to hire without needing to set up their own subsidiary, but also engage a person in an employment relationship. And so how that works is you have an employer of record company like Globalizations that has their own legal infrastructure and entities around the world. The company identifies the talent, and the employer of record employs that person directly through one of their companies. So for Globalization Partners, we would employ this individual through our Canadian entity. We are responsible for employment taxes, payroll tax, and deductions, making sure we have a compliant employment contract in place, making sure things are run compliantly from the HR and employment side of things. And it really allows that individual to focus on the business needs in the particular country, and the company to focus on that as well, without needing to take on sort of the headache and burden of thinking about setting up a subsidiary, or, how do I remain compliant with Canadian employment laws? Do I need to now draft a Canadian, human resources policies or handbook, those types of things? So it can be a good option. And companies use it in a lot of different scenarios. They use it oftentimes in terms of testing a market, or if you want to get someone on the ground quickly in a market. So it can often serve as sort of an intermediary solution where you get someone on the ground, you sort of see how things go. If they go well, and the company says, we want to really build out a sales team in Canada, then the company may decide, okay, now it makes sense to set up our own entity and transition those employees over to our own entity. But it's a mechanism that allows companies to sort of test a market or quickly enter a market without fully committing to corporate presence there.
Yep.
And or if the company decides they just want to have this one person in Canada, it can be a permanent solution where the company sort of says, I don't really ever want to set up an entity in Canada. It doesn't make sense for us from a cost or risk or tax perspective. And so they'll use an employer of record long-term for sort of 1 or 2 employees in a country. Great.
So companies like Globalization Partners are not only advisors, you also serve as the employer, which allows the employee to focus on doing their job, and the employer to just focus on getting that employee up to speed on the services they need, and you take care of the employment and compliance issues.
That's right. Yeah.
Okay.
We are the legal
Good.
employer of record.
Short-term or long-term. Let's move on, because we're going to have an opportunity to talk about these options with some of the other scenarios that we've been working on. Oops, there we go. There we go. And our second scenario involves a Chinese auto parts company that set up a U.S. manufacturing facility so that it can make auto parts in the United States and avoid paying the 25% import duty that the Trump administration has imposed on Chinese goods, which the Biden administration has left in place. The Chinese parent company, which also has a distributor in Germany, is working with an independent contractor from Germany who's experienced and is an expert in setting up large production line equipment. The Chinese parent company likes that German consultant, that independent contractor, who they have treated as an independent contractor in Germany, and the German authorities have not challenged that. And the Chinese parent company wants to bring that independent contractor to the United States, not forever, but for a short term, to help the US set up, calibrate, and troubleshoot the US subsidiary's new production line. And I'll point out that some of this is Chinese technology, but Germany is a great maker of production line equipment. So some of that production line equipment is coming from Germany. In this case, Mary, we have someone who is moving from their home country to a different country, namely Germany to the United States. And so we do need to address the visa issues first, or at least as part of this analysis. Would you like to talk to us about some of the options that are available and what we would need to do to help that Chinese client with the German consultants be compliant?
Absolutely. So Whenever you have a corporation that has a office or a company set up in the US and also has companies in other countries, subsidiaries or affiliates or parents, we always start thinking about our L visas. These are for multinational companies and for transferring employees to the US from other countries. There are a couple of types of those L visas. If you have an executive or a manager, that is called an L1A. And if you have a specialized knowledge employee, that's an L1B.
So this person, Mary, is not a management, but he is an expert in these lines. So would understanding that you might want to see his resume, do you think he'd meet the criteria for being an expert?
Well, we have to dig pretty deeply into that. It's at least a possibility and something we would start by exploring, because the L1B is a good visa. It will give him up to 5 years in the United States. And so it's something worth exploring. Now, our government agency, USCIS, scrutinizes L1Bs very closely. They want a lot of detail about why this is truly specialized knowledge, why it's not something that's widely held, but it very well may be that he would qualify for an L1B.
But all right, so but I think you said it has to be parent sub, right? Because he meets. Let's assume he meets the expertise criteria, but he's not coming from the Chinese parent. He's a German consultant. Would we have to deal with that issue too?
Yeah, we would, but it's not necessarily fatal. If I had received a call from this company before they hired him to work for them in Germany, I would have said, hey, if you can make him an employee, that will be an easier case. It takes one, less issue to have to address. But the fact that he was paid as a contractor in Germany is not necessarily fatal. Some of it will depend on how he was paid. If he was paid directly, which, from Nicole's perspective, may be a little bit of a problem, but from a L1B standpoint is the better way to go. If he was paid through Nicole's company, that's going to be a little bit harder. It's probably not going to get through. So, because we're going to have to show that he was paid by our client, the client who's trying to get the visa or one of its affiliates or subsidiaries. Okay.
We got a couple of questions. I'm going to talk about them quickly. Nicole, I'll let you talk about some of them a little bit later. One question was, if somebody is misclassified, and I think in terms of where we are in our discussion here, we could have a misclassification claim, Mary, from an immigration standpoint, where we could also have one from an independent contractor versus employee standpoint. And Nicole, would you like to comment for just a second on what happens if somebody is misclassified? Namely, what happens if you call them an independent contractor and they are in fact an employee?
Yeah, so misclassification claims are exactly that. When a worker alleges that they were classified wrongly or treated as an independent contractor when in reality they were an employee, and thus they should receive all employee rights, benefits, payments. It could come up in the instance of independent contractor relationship. It could come up in an instance where you've asked your independent contractor to set up their own entity and then you're contracting directly with their entity. But really any sort of individual worker can bring that in a country. And what the court will do is look at the reality or the substance of the relationship between the company and the worker and make a determination of whether they were truly an independent contractor, looking at the factors that each country establishes, or whether the relationship was one of an employment relationship. And then if that's the case, often the consequences are penalties, as the company is required to sort of pay back taxes from when the individual was engaged, back wages, any employment related benefits. There's often penalties that are assessed in terms of getting it wrong. And then often these misclassification claims often come during the termination phase when you're ending the relationship with the individual. Generally what happens is, the relationship goes south and the contractor doesn't like the fact that you're parting ways and then brings a misclassification claim. If the individual should have been an employee at termination, they should be receiving notice as required in country. Oftentimes there's statutorily required severance and various other benefits that need to be paid. And so in a misclassification claim, the court is essentially assessing all of those factors and essentially saying to the company, you did this wrong. You need to make all of this whole in the following ways by paying these sort of back taxes, back fees, and paying an assessment to the individual worker. If you start to get a lot of misclassification claims in a particular jurisdictions, you sort of put yourself on the radar of the authorities for doing sort of a more in-depth internal investigation into your operations and to sort of see if you're really, if you're just trying to classify everyone that works for your company as an independent contractor incorrectly, and that can come with different, more substantial penalties.
Right. So if you do it wrong, particularly if you do it wrong to try to save money, you could end up paying what you should have paid in the first place, plus fines, penalties, scrutiny, shipping and handling, etc. All the other things that go, like every area of the law when you don't do things correctly.
Exactly. I often used to use France as an example because they have such high social charges. So if you're paying an independent contractor 100,000 euros, the authority is going to treat that as net income. So then it's going to assess, social charges in France on top of that, which is generally around 46%.
Right. You're going to gross it up.
The amounts grow very quickly.
Okay, good. I want to get back to Mary's immigration options here for our scenario number 2. Mary, when we talk about somebody being an employee, can they be a part-time employee?
Unfortunately, no. And we see this happen a lot where a company has someone working in another country for them, or actually we see it more often when they are looking for a way to get them to the US and they say, okay, well, we'll have them work for us in the UK or in India for a year, and then they'll be eligible to move over as an L employee to the US. But this person has a job elsewhere. So they just have them work part-time for a year, and then they come to us and say, okay, well, they've worked with us for a year. Let's do that L. And I have to say, well, actually, you only knew part of the law. It has to be full-time employment. So they actually have to have worked for the company, whether as a contractor or as an employee in a full-time role.
And in this case, you're talking about the full-time employment with the foreign transferor entity.
Yes,
right?
with the company outside the US, which they have to have done for a full year within the last 3 in order to qualify to be a transferee to the US.
Where does that work have to occur? In this case, we've got a Chinese, quote, parent company, but this German expert. Does the work have to be in China? Can the work be in Germany? If the work's done in Germany, who does he work for? Does he have to work for the Chinese parent in Germany?
Well, it can be set up a lot of ways. I know that my tax friends here on the call may have more issues with it, but from an immigration standpoint, as long as you can show that he was paid by a company that has the right relationship to the US company, honestly, when you're doing an L, the location where the person worked in the foreign country really isn't one of the key issues. It's, were they employed by a foreign entity with the right relationship to the US entity? And when I say employed, also it could be that contractor, as I said, although the employee arrangement is the more straightforward one. So, the fact that he was working for the Chinese company, let's imagine he was being paid by the Chinese parent as a contractor in Germany. I don't think that's going to be fatal to the L. It might be something that gets a little bit of scrutiny as far as whether he was actually employed by that Chinese entity, but it would not typically be something that I would say, okay, that's a no-go.
Okay. The question that leads me to next is, what options would be available for employing him for the Chinese parent to employ him in Germany if they don't have a subsidiary in Germany? And I want to make sure we're staying on schedule here today, but the options there, I think, are very much like the options, Nicole, that you raised for our original India to Canada issue. And although the answers may be different, I don't think the questions are any different and the criteria are any different. So I want to make sure we have time to talk about some tax issues. So I'm going to move on. If this person, this German technical expert, becomes eligible for one of the visa types that Mary has explained, and he comes and begins working in the U.S. under our scenario, working in the U.S. temporarily to get this line set up, where does he pay his taxes? Chris and Walter, I'm going to want both of you to weigh in on some of these tax questions. Chris, is his tax obligation to China, Germany, the U.S., or more than one of the above?
Yeah, so we can take China out on the assumption that there is no actual work performed in China.
Even if the Chinese parent pays him directly?
Yeah, that doesn't really matter. I know we're covering that later, but
okay.
It's really about where you perform your work, not where you are paid from. And the way I always attack that question is, if it counted where you were paid from, we'd all get paid out of Dubai where there's no income tax. So
yeah, right. Okay.
That's the easiest example to show. So but then the relationship between Germany and the US comes into play. And in all likelihood, on an L1, based on the nature of the project, that person from Germany would be paying US tax and state tax, depending where the project is taking place. Whether or not they have an ongoing requirement to file and report in Germany would depend on the length of time that they're going to spend out of the country. And so in say a 2 to 3 year project, let's assume we're looking at that length, we would expect that person to break German residency and then pay US federal and state tax. There are scenarios where a treaty may apply and they wouldn't have it, but that would be on a very short-term time frame only. And there are a lot of qualifying aspects to treaty exemptions that are both good and bad, but always need to be met for somebody to be fully exempt from tax. And
are you talking about a tax treaty or some other kind of treaty? A
tax treaty, yeah. And there are, I mean, one of the things that is also a challenge in the US in particular is that we have not only the federal government, but then we have 50 different states who like to have their own rules. So for example, if this was in California, the project, California wouldn't recognize that treaty anyway. So, New Jersey is the same. So there are many different combinations that can play in here. But the thing I think the main point to make is that the primary taxing rights are based on where the work is performed. And so in this case, with a true move into the US, that's where their primary tax bill would be based.
Okay. And Walter, I want to see if the same result would apply if this German employee or German consultant was for the benefit of the Chinese parent going into Argentina. Would Argentina also say local labor laws, local tax laws apply?
Yes, that is correct, Dale. I would say pretty much the same things that Chris was explaining. Argentina would apply taxes on those services or those tasks performed within Argentina. And as Chris was saying, it would be relevant whether the individual is getting paid or who is making the payment. Argentina would have taxing rights over those salaries or the payment for those services performed by this individual.
Okay, and Walter, does Argentina also have a national tax as well as a state or provincial or local tax?
No, we only have a federal income tax. Of course, we have 25 provinces who have taxing rights, but would not cover this, would not apply to this kind of services. My only concern would be the federal income tax. But another issue that we should bear in mind is the risk of creating a permanent establishment for the German company by having the individual working in Argentina.
What does that mean, to have a permanent establishment?
Well, basically, that is the minimum threshold above which Argentina would apply income tax to the corporate entity performing services within Argentina. In other words, a permanent establishment means the foreign company having a fixed place of business within Argentina, or an individual performing services on behalf of that foreign company, in this case, the German company. And the consequences of this is that Argentina would apply income tax to that local presence as if it was a local company, applying the corporate rate and allowing deductions for that local presence.
All right, hold on a second here. So this is for Chris and Walter. So you're telling me that if we paid, the Chinese company paid, or the Germans paid, or even the US paid directly, an employee or someone who, as Nicole said, is properly treated as an employee in Argentina, we could have not only employee tax, but employer withholding obligations and corporate tax obligations?
Yes, that is correct, at least from an Argentine perspective. And of course, the permanent establishment issue is a facts and circumstances analysis that we need to make. It's difficult to make general conclusions here, but that would be an issue that we should definitely pay attention to, because that individual working in Argentina for the German company or the Chinese company, that would be another discussion. Who is this guy working for? Who is the one, or which company has the local presence in Argentina? That's an issue that we will definitely need to address. And my final point here, Argentina has tax treaties with many countries. Germany is one of them, under which the definition of permanent establishment included in Argentine law could be amended or tailored. So the bottom line is, if we have a tax treaty in place between the two relevant countries, in this case, Germany and Argentina, we need to read that treaty and see what that treaty provides for this kind of situations.
And that's very interesting. And Chris is.
I mean, the only thing I would add to what Walter said is this idea of permanent establishment is not an Argentine concept. It's a global concept. So yeah, if somebody's coming from Argentina to the US or Canada, we would have to look at it the same way of your people doing work for you in that country can lead to a corporate filing and corporate tax bill.
Yep.
So even going back to the India-Canada example, that again, there is a treaty between those two countries which defines that an agent who can sign contracts for you, so that sales role sound like it, could create a permanent establishment. Even if you had them under an independent contract approach, you could still get hit with a permanent establishment assessment. Canada actually has deemed permanent establishment rules where a single project over 183 days is instantly a permanent establishment. Many countries throughout the world have similar aspects, and it is typically something that is addressed in a treaty of what constitutes a permanent establishment. But you should remember as well that that treaty network is not guaranteed. So for example, and it always surprises me when I remember this, is that the US and Argentina do not have a tax treaty.
Are most of these tax treaties bilateral, Chris?
Yes.
Meaning just between two countries. So it's not like NAFTA, which is 3 parties, or like the EU, which is a whole bunch of countries. The tax treaties are bilateral.
The OECD provides a sort of a treaty template to be used, but then it is up to each individual country to come up with its own bilateral agreements. And another thing which I'll raise again later, though, is to remember that these are income tax treaties and not social security treaties. And therefore, when you're addressing this issue of if somebody is taxable, what is that? You then also have to think about Social Security later on as well when you're looking at your employer requirements.
Are there any Social Security treaties?
There are. We don't call them treaties. For some unknown reason, we call them totalization agreements.
Okay.
But for example, the US has, and I don't know the exact numbers off the top of my head, but certainly 100+ income tax treaties and less than 25 Social Security agreements. So
those have to be analyzed separately.
Yeah.
And you use the odd number 183 days. Where does that come from?
That is a test that is often used within tax treaties to establish whether somebody is going to be taxable in that country. Now, often, and there is a myth out there that if you're in a country less than 183 days, you don't have to pay tax. That's not always the case, because there are qualifying criteria. And then there can be, even if you're not taxable, there are opportunities when you still have a reporting requirement as an employer.
Yeah. Okay. And for anybody in our audience who hasn't done the math, 183 happens to be half of a year, half of a leap year, slightly more than half of a regular year. So 6 months is the rule of thumb for when you start worrying about some of it. Now, Mary, when we get ready to choose a visa type, that could have an impact on taxation, I assume. We'll come back to Chris and Walter on that question. But who cares what kind of visa it is, as long as it gets you into the country legally? Are there other factors to consider other than which one's the easiest? I mean, why not just go in on a tourist visa at the airport, do what you need to do and leave?
Well, right. A lot of people make that mistake. And the truth is that every time you enter a country, you enter with a group of rules that govern what you can and cannot do in that country, even when you are visa exempt. So, you may come in on ESTA from Europe. And
what's ESTA?
It's a visa waiver type program, and you can come in for 90 days. And people say, well, I wasn't on any visa, so I could do whatever. Well, that's not really true. You're entered on, what shows up in your Customs and Border Patrol file is that you came in on a waiver, either for tourist or for business purposes, and you're governed by a set of rules. And there are very few types of entries that allow you to work in the US. Some other countries.
How can you say you can't work if you just told me a minute ago that you came in on a business visa?
Well, a business visa, we're going to talk a little bit more about business visas, I think, a little bit later, but business visas allow you to come in and engage in non-work meetings, business meetings with clients, sometimes certain sorts of trainings, but not productive work.
Okay. All right. Is there any other factors that people would want to consider when they choose visas? For example, are student visas better or worse than working visas?
Well, I guess it depends on their ultimate end goal. If the end goal is to ultimately stay in the United States, then it is really important to make sure that you try to come in on a visa that allows for what's called dual intent, being here on a temporary visa, but with the intent to try to become a permanent resident. Certain types of visas don't allow for that or require a lot of extra hoops to jump through to be able to get to that. So you do need to think about what your end goal is. And the government in the US, I think most governments don't take kindly to people giving false information about why they enter a country. And so one of the biggest problems is if somebody comes into the US knowing, for example, that they intend to get married, but they come in on a tourist visa, then they decide they want to try to become a permanent resident, that could become a really big problem for them. So every time you enter a country, you need to really understand what are the restrictions, and if you have other purposes, it may be much better in the long run to explore the right type of visa rather than just getting in and then doing what you want.
Do immigrant communities in any country uh, have a sense that some visas are higher status or better than others?
Definitely, yes. And sometimes that information is accurate. Oftentimes it's based on a nugget of truth, but almost a lore has risen up about certain types of visas. And so you often do get companies will have employees coming to them saying, I want you to get me this because this is what my friend got, and that worked out well for them. And sometimes that information is true, sometimes it isn't so true.
Okay. So when choosing a visa, I'm hearing you say you need to think about what you're allowed to do under that visa, how long it allows you to stay, whether it's a path to permanent residency or citizenship, and perhaps how much status it has in your friends' community of other agreements. And those are all things, and the extent to which it could be changed by relationships. And I'm going to give you one more question, Mary, then we need to move on to our next scenario. What happens, we've talked in this example about the fact that it is a parent-sub transfer, a parent-sub relationship that makes this visa, the L visas that you mentioned, possible. What happens if we have, let's say Toyota has a transferee from Toyota Japan to Toyota US in one of their subsidiaries, and then they sell that US subsidiary completely to a third party. Is that visa immediately no longer valid?
Yeah, that's a problem for the employee who is here in the US, because one of the things about an L is that relationship on which the L was based has to continue to exist throughout the person's employment in the US. And so if the companies become unrelated, it's not even a situation where you can apply for a transfer unless maybe there's a different Japanese sub here in the US that they could transfer to. But yeah, so it is a big problem. And we see this a lot with companies that do a lot of changing of their corporate relationships. Sometimes the L, while it's a good one and one of the visas we look to first, sometimes it's not going to be the best one if it is a company that is constantly shifting around its relationships and buying and selling subs.
Okay, good to know. I want to make sure we're staying on time. Let's talk briefly about benefits. In many countries, healthcare is provided by the government, optionally or it's mandatory. In the United States, we have a lot of private healthcare. Let me address this one to Nicole. Nicole, if I send a US employee to the UK, where they have national health care, does that US person have to worry about how they're going to get their health care? Are they going to walk into a government clinic in the UK with their US Blue Cross Blue Shield card and say, here, treat my broken arm?
Well, unfortunately, the Blue Cross Blue Shield card will not get them very far in the UK. That is going to depend on sort of how the employee gets to that country, under what kind of visa they're there for. Are they on sort of a tourist visa? Are they on a work visa? So it'll depend on each sort of scenario on that. I would say one thing to keep in mind is if you're sending an employee on sort of a shorter term assignment to a different country, oftentimes the national healthcare system doesn't necessarily kick in for that individual. But one thing for companies to keep in mind is if you have sort of a global travel policy, you want to review the language in there, because some of those policies also provide for medical care while the employee is traveling. And so there is a way for to ensure that employees receive proper medical care, attention, and coverage while they are on an assignment to a different country. If an individual is really legally working and is under an employment relationship with an entity in country, they are going to need to be registered with the national healthcare systems, and the employer is going to need to comply with pension requirements and those kinds of things as well. There are certain mandatory benefits that are required from an employment perspective if you have an employee in a particular country.
Yep. And we don't have time to get into all the benefits questions today, but everyone should have benefits questions on your checklist as you're thinking through this, because, and I'm speaking at the moment solely from a U.S. perspective. Other than Social Security, retirement is often done by employers rather than the government through 401k and other retirement contribution plans, and healthcare is often done. And to the extent that you provide somebody with a car or life insurance, all of those things need to be reviewed with your benefits group. Sometimes you can get a separate insurance policy, as Nicole pointed out, short term for travelers. You need to ask yourself questions like, well, if I pay into my US 401k retirement plan, I don't have to pay tax on that portion of my income this year. But if I'm earning some of that money in Germany, Germany may say, 401 what? I don't care. You earned money. You got to pay tax in Germany on that. So that should be reviewed, as well as Social Security issues. And Chris, I want to talk about Social Security just a minute, and then we need to move on to our next scenario. Going back to our original scenario number 2 here, we got the Chinese parent, the German expert, and the U.S. individual and the U.S. work. Do they pay into Social Security for that short-term visit? And if they do they collect benefits 30 years later from the U.S.?
For a German coming into the US, there is a totalization agreement, one of these Social Security agreements I spoke about earlier. So in a typical setup, we'd see the German remain paying into the German system, with then a certificate of coverage in place, which is just a form issued by the German government that allows them not to pay US Social Security.
So the German employee turns that over to the U.S. employer and says, "Don't withhold Social Security from my paycheck because I'm covered by the German system, and I'm going to pay there, and I'm never going to make a claim against you in the United States."
Yeah, but again, the challenge that you have there is that network is not very substantial. So if that person is coming in from Mexico or Argentina or Brazil or India even, we don't have agreements with them. So in those cases, somebody coming here for say 2 years on a project, they will pay into Social Security. They will not qualify for benefits. So it's basically just a sunk cost. That's not always the case around the world. There are other places that you have to pay Social Security or a pension contributions, such as India, but you can actually pull those out when you leave, or a certain amount of time after you leave, which creates some challenges for the employer, because those funds in India, for example, could get quite substantial, and then the individual can just pull them out. Are you going to try and recover that somehow? Or, you have to word the agreement very, very closely when you're in those sort of situations.
Okay, so enough to put that on our issues list. And we've talked about retirement funds. Some of this is law, as you mentioned, I think, Chris, and also Nicole, you got to look at what the benefit plan says. Somebody's going to have to pull it out and say, who's eligible, who's not eligible. And before you say to an employee going to the UK, hey, you're not going to be part of Blue Cross Blue Shield anymore because you're outside the country. You better make sure your benefit plan allows you to exclude them, because otherwise you could have a benefit plan compliance issue, because you have not made all eligible employees, you've not given them the opportunity to participate, even if they would choose not to participate.
Yeah, just very quickly, Dale, the flip side of that is and a scenario I've seen is where if you have a remote work request and oh yeah, you can go and work in Western Europe, wherever it may be, and you leave them in the 401k, that could in turn disqualify your entire 401k plan if they're no longer a resident of the US or not an eligible employee.
Exactly
So
right.
very,
Yep.
very serious sort of complications.
Yep. Agreed. All right. So let's go on to scenario number 3, where the facts that were presented, and Mary, this is a question for you, were true at the time of entry, and then they changed. In this case, we have an Israeli citizen who works in Israel for an Israeli computer security company. And think of somebody who does encryption or deals with hackers or cleanup after hackers or ransomware has been detected. And the Israeli company sends that good Israeli computer expert to the United States to deal with one of the Israeli company's US clients about its cybersecurity needs. And the original plan is they're just going to come in, assess the situation, figure out what's going on, and then go back home and do the work remotely from Israel. And therefore, they don't plan to pay any US taxes on that person. And they get them in here in some kind of short term, as you pointed out, Mary, maybe they even decide on their own it's going to be a business visa because they're just coming in for a meeting or two. And then once they're here, they see a number of problems unrelated to the security issue that need to be fixed. And the parent says, well, tell you what, we'll pay for all your travel expenses. You just stay there and get them fixed before you come home. Can we do that from a visa standpoint?
Yeah, so we see that a lot. This is, you asked, so what does a business visa do? This is a classic situation of originally the proper use of a business visa. You're going to come in, you're going to see what the client needs, and then you're going to leave and do those skilled or unskilled labor outside the country. That's what these business statuses are meant for. So the person was coming in for the right purpose, but when things changed, that does not change what they were allowed to come in to do. And so once they start doing anything that looks like skilled or unskilled labor, then they, or sometimes it's said, is it productive of work? Then at that point, they would be considered to be working in the US, but they don't have work authorization when they came in as a business visitor. So they are engaged in unauthorized employment in the US unless they leave. You know, usually the easiest thing is to leave, get the right visa, and come back.
Okay. And do they have to go back to Israel, or can they just take a weekend trip to Toronto?
Well, you know, like maybe they could take the weekend trip to Toronto, but probably not, because, well, right now you can't even get appointments.
Because setting aside COVID, yes.
You know, one of the countries that actually is a really good place to go, usually if you could get an appointment at the consulate, Mexico allows temporary work within their country for, I think it's like about, I'm not a Mexican immigration attorney, but I think it's at least 14 days. It at least covers the COVID quarantine period for coming to the US from certain countries. And so Mexico has basically had its laws put in place so that you can go and lawfully be doing your work for your foreign employer within Mexico. So, you know, there might be times where you could travel down, spend a couple of weeks in Playa del Carmen. It's a lovely place, do your work, and then get back. But right now, all of those options are made incredibly complicated by the fact that it's very hard to get an appointment at a consulate to get a visa once you get there. So someday our consulates will function again like they used to, and then there are a lot more options than what we currently see.
Okay. So all of this means that what this computer expert told the immigration officer at the airport when she came in is relevant. The visa category she came in is relevant. The kind of work she's doing, the time period she's here, all of those things are relevant. And whether or not she's taxable for the work she does in the US will, as Walter and Chris explained, depend in part on whether there's a tax treaty with that country. Let's move on to our fourth scenario, because I want to make sure we do leave some time for questions. I left this one for last because I think it's such an interesting fact scenario. And we have not a lying employee, but a lack of full disclosure employee. And this is an interesting one. I had something similar to this happen with one of our clients. A very skilled job applicant applies for a job with an employer, and the employer is located in New York City. New York City, for those who are not part of the US workforce, is an exciting place to work, but it also has high state and local, that is city taxes, which you pay on top of your federal taxes. She tells this employer that she's applying for the job with that she lives in New Hampshire, which has no state income tax. By the way, be careful if you ever buy a lake house in New Hampshire, because they have high taxes on property, and often taxed by the foot for your lakefront property. That's a side issue. And that she wants to work remotely and get paid as a New Hampshire resident. The employer says it's fine for her to work remotely, that she can do that, the kind of work she's doing. She also mentions in passing during the interview process that her husband's from Argentina, and that she occasionally visits family down there with her husband at her own expense, but that she'll be available to work a regular schedule on those occasions when she's visiting family in Argentina. The company makes her a job offer, and she takes it and signs up for healthcare. Shortly thereafter, she announces that she's pregnant and is planning to take a parental leave. She didn't mention the pregnancy during the interview process, but the company didn't ask about it, as is appropriate. They should not have asked about it. And the company says to her, of course, if you're eligible for a parental leave, like any other employee, you're certainly allowed to take that. The company also finds out, however, that her New Hampshire residence is really just a small summer cottage that she and her husband spend short periods of time in. And that while she was with her previous employer in New York City, she spent most of her time living in a spare room with her parents in New York City. And now that she has this new remote job, she plans to spend not some, but most of her time in Argentina. She wants the employer to, in addition to paying for her parental leave, which they've agreed to do, to pay her in US dollars and treat her as if she were a New Hampshire resident working in New Hampshire. This is like a law school exam for those of you who haven't been to law school. Plenty of issues to dig your teeth into. Walter, since we've got Argentina involved in this scenario, can you start us off with identifying a few problems and issues that this raises? Her request to be treated as a New Hampshire resident.
Yes, sure. It's not an easy case because it involves many aspects. I would start by saying that Argentine law requires the existence of a local employer duly registered before the tax authorities to have an employee. So we have a strange situation where we have an individual working in Argentina, and probably for most of the time, at least at the beginning, not knowing the employer that the individual is in Argentina. I mean, it could move to Argentina, start working remotely from Argentina, and the employer might be, ignoring that circumstance. As we were discussing before, the work done in Argentina involves payment of taxes and social security contributions within Argentina. And as I was saying, in theory, we need a local employer to do that because employees do not file tax returns in Argentina. The income tax and social security contributions are fully made by local employers through a withholding upon salary payments. So we have this strange situation where we have an individual working in Argentina remotely. But at the end of the day, as I was saying, Argentine law applies to this service or to this labor relationship. And therefore, the individual would have to pay income tax in Argentina. And under the law, if the employer does not apply the relevant withholding, or if no employer exists, as we are describing, the employee, this individual should file her own tax return and pay taxes in Argentina. That's the thing to say. And secondly, again, it's a concern. I don't want to worry everybody here, but this individual working permanently, let's say in Argentina or for certain number of days, could create a local presence subject to tax in Argentina for the employer. Because at the end of the day, it's like having an employee on a permanent basis in Argentina performing services for the foreign company. All this discussion seems to be a little bit strange in days where the pandemic allows employees to work remotely on a permanent basis, let's say. This is not new, but with the pandemic situation, all the classic discussion seems to be a little bit old. We probably need, from a tax perspective, to update our discussions. So those are the main issues to raise immediately.
Yeah. Okay, good. In terms of the amount of maternal or parental leave that she's going to be entitled to, does Argentine law say anything about that? When you said that she's subject to Argentine labor laws, does Argentinian law have any rules about how long parental leave should be or must be?
Yes, it is a 3-month period, which can be extended without payment of salary at the option of the employee. But again, that's a right of the employee. It's not an obligation. So
this employer who thinks that their 6-week policy is going to be sufficient because that's what New York and New Hampshire would allow, may find that the employee later claims that they are in fact entitled to a longer leave. Is that right?
Yes, but let's analyze this under a practical perspective. That is correct under Argentine law, assuming there is a local employer to which this individual would try to impose this license. But it's difficult to think of a claim by the employee to a foreign company without a local presence in Argentina. I mean, from a practical perspective, it is difficult to see how the employee would enforce what Argentine law provides.
Yeah, okay. How about this question? The HR manager who hired her is very supportive of parental leaves, but not very excited about her misrepresentations about where she was going to be doing the work. Can they revoke the offer?
Yeah, I mean, I would say that should be governed by the law of the place where the company is and made the offer, which is not.
I think so too. Yeah, and we don't have a New York labor law expert on this call, but I suspect that the advice that we would be given is, if you are going to revoke the offer or terminate the employment, be sure that the grounds on which you explain that termination is focused on the misrepresentations during the interview process and not on Israeli citizenship, the fact that she's claiming a maternity leave or anything else. It has to be based on the things that are legal grounds for adjusting an employment relationship.
And then, together with that, it should be clear that part of the main aspects of the offer was that the place where the individual would provide the services. I mean, it should be really material that she moved to Argentina and plans to provide services from Argentina. That should be misrepresentation based on the fact that it was basic that the services would be provided where she said it would be provided.
I agree. Okay. All right. You've talked about taxes already here and the Argentinian labor and employment laws. And we've talked about revoking or firing her. We're right about on time here in terms of 11:15. Let's get to some of those questions that we've had. We've talked a little bit about misclassification claims. Nicole, back to you. If we have a this is a question from Andrea back to your first 5 scenarios. If Globalization Partners is set up as the employer, what happens in the event of a termination dispute? Do you handle that? Do you help with it? Does the company ultimately bear the expense? Tell us how you would deal with that. And because unfortunately, every employment relationship ultimately ends in a separation, whether through retirement or otherwise, right?
That's right. I mean, when you're engaging with an employer of record, you're going to want to look at some of these terms in the master services agreement with the employer of record, because it should spell out in the agreement where liability lies, who bears the risks, and some of this will be covered by indemnification sections as well. But
so that's an agreement. Sorry, Nicole, that's an agreement between the de facto employer and the service provider, whether that's Globalization Partners or somebody else. This is not an agreement with the employee. This is an agreement.
That's correct.
Okay, so go ahead. Yep.
The other thing to consider is that the employer of record, as the legal employer, needs to be the entity making any employment related sort of decisions and actions towards the employee. And so you want the global employer of record to be highly involved, guiding you through this process and telling and advising you sort of like what you can and can't do in a particular country. We often see instances where clients try and attempt to terminate the relationship on their own and just notify a particular employee, oh, you're not performing well, we're going to terminate you. Oftentimes in most countries, it's required to establish cause or justified cause to terminate. And so you can really create sort of a sticky situation if the end client receiving the services, who is not the legal of employer, is telling this individual that they're terminated. That's almost guaranteed some sort of claim, whether unfair dismissal or otherwise, or challenging the whole relationship. But the employer of record will negotiate and deal with sort of the termination questions. As you sort of mentioned, in many cases, you do end up going down the route of a mutual termination or a settlement agreement where there is a contested separation. And that will be, facilitated by the employer of record, and all the documentation drawn up by the employer of record. So when it comes to a contested termination, that's often the path you go. And you want an employer of record that works with you collaboratively in that approach, and doesn't sort of say to you, yeah, sure, go off and negotiate this settlement with this individual and just tell it how it ends up, because that does not go well.
All right. So putting it in layman's terms, Nicole, the employer of record, Globalization Partners or somebody else,
yeah,
will serve in that role, will help advise in that role, but ultimately the cost of that termination will be borne by the de facto employer, presumably, unless you really screw something up.
That's right.
Okay. All right. Our next question is an interesting one because it's not a topic we've talked about, where when we have people working from home or working from anywhere, and I have friends, I'm sure all of you have friends who said, I am going to go to my more pleasant non-downtown place to live to do some of my work. This question from Gina says, with all the pandemic work from anywhere remote gyrations, how are companies handling local requirements? Like, is there any waiving of the medical license requirements allowed in telehealth? And I have actually looked into this, not for doctors, but for dentists. Some of you may know that traditional wire braces, which were the scourge of all of our adolescent years, are now being replaced in some cases by clear aligners. This is a much simpler process. You make an impression by biting into some clay, and then the orthodontist sets up a series of trays that adjust them, and they're clear. You can wear them while you sleep. But that's something that can be done by an orthodontist or a dentist at home, wherever they are. And similar systems are coming up where somebody says, hey, can you take a look at this red spot on my arm? or can I talk to you over a video chat about this fever I'm having? I don't think it's COVID, but it has been bothering me. There are some interesting regulatory questions, which aren't tax questions, although they may have tax impacts, and they're not employer-employee questions, but they are questions about, does that professional service provider have to be licensed in the place where the service is being provided? And the answer, I think, is yes. Most state, at least in the United States, most state regulatory bodies, and these will be those that regulate medical care, nursing care, dental care, do require that someone providing service to residents of that state have to be licensed in that jurisdiction. What a problem for somebody that wants to hire one dentist or one COVID expert to take calls from all over the country. If you now find out that 47 of the 50 states require you to have a local expert answer those questions. As Walter pointed out in one of his comments, the law hasn't caught up with the technology yet, and it may, but at that point, I think that's where that stands. Our next question is from someone called Anonymous, and it says, many companies have allowed people to work remotely. This was intended to be temporary, but of course has now been going on for 18 months for some people. Some employees may have chosen to work from another country or another state. Is there a legal concern with respect to the time they've spent there already, and whether or not they're allowed to continue to do so going forward? The answer to that is, I think Walter answered it. And the answer is, nobody's enforcing it very rigorously yet, but yes, there is a problem. If this person who's paying New York taxes or New Hampshire taxes, or New Hampshire lack of taxes, is in fact working in Argentina, the employee and the employer should be having a conversation about how the withholding should be handled and making sure that's adjusted. Chris, go ahead.
Yeah, I was just going to say, from a tax side of things, a lot of people may have remembered that there were some concessions that were put in. The US put some in, UK, India. A lot of countries kind of came out right at the beginning of the pandemic, but just about all of those have now been shut. I mean, India's concession on residency was literally a 2-week period at the end of their last tax year in March 2020. So if you've had people in India, for example, in that time period, you should be paying Indian withholding. And that's very true around the world now. The UK have sort of suspended that. Ireland have suspended that. So the only one I think that's still going is the commuter relationship between Singapore and Malaysia for people who would traditionally commute into Singapore. I think that's still going, but it's probably 5 or 6 weeks since I last checked on that. So that may have ended as well. So.
All right, Mary, you had a thought on this too.
Yeah, we've seen this a lot in regard to even within the United States, people here on, for example, an H-1B visa, which is a specialty occupation visa. Those are very specific to the locations that you file that petition with the government for. And so we've had people who during the pandemic were like, look, I'm working alone in my apartment in this city and I have relatives 3 states over. I'm gonna go stay with them. But didn't think to tell the company because what did it matter? They were just, working remotely either way. Well, there are different wage obligations depending on where you work. And so companies are now looking at that and saying, oh, wait, we need to go back and up their pay for that 6 months that they worked there because there was a higher prevailing wage rate in that other place. And the answer is, yeah, probably you do. And that foreign national now, to be honest, may have to answer to future questions from US immigration authorities, whether they've ever violated the terms of a status they'll have to say yes and explain. And I think that ultimately the pandemic will be taken into account and there will be some leniency given, but it certainly is going to be a complication that we're going to be working through for a decade, I think.
Yeah. Nicole, did you have an additional thought on that one?
Yeah, I was also going to say with this remote work sort of revolution that we've seen due to the pandemic, there are a lot of individuals or cases where work from home is now sort of becoming treated as work from anywhere. And I think from a practical standpoint, I mean, both Mary and Chris have addressed a lot of the issues from tax and whether you can legally work and all of that kind of stuff. But from a practical kind of view, as a company, it's really important to start enacting policies around this and putting some parameters in place for employees that really specifies, like, you know, you don't have to work at your exact like home location, but you need to stay, if you're in the United States, within the particular state that you're working in, or if you're going to be out of the state or out of the country for more than a specific time period, a month, whatever the company establishes, you know, you need to get advance approval from the company. I think those policies then establish or at least tell to sort of the employee population, you can't just go work from a beach anywhere, even though it would be lovely, or, you know, just become a digital nomad around the world. They sort of say, like, here are the parameters for where you can and can't work. And if you want something different, you need to come to the company to discuss it, because that really allows the company then the preparation to take the time in advance to sort of say, will this create taxable presence? Will we need to be paying payroll in this particular jurisdiction? And come up with a plan in place to address it compliantly from the beginning, rather than being on the back foot and finding out 3 months later you've got an employee who's been in Bali for 3 months and you're just finding out about it now.
Okay. I want to do one more question, and Pete, and then we're going to let you wrap up.
Okay. I'm sorry, Dale, I just want to make 2 short comments.
Oh yeah, please go ahead, Walter.
Okay, number one, from a tax perspective, it is crucial the cooperation of the employee to let the employer know what is happening, where he's working from. Otherwise, it's impossible for the company or for the employer to know exactly where to report, what kind of taxes to pay.
Yeah.
That's number one. Number two, due to the pandemic, many employees were restricted to move from where they were, where the pandemic started. Just to make a comment that the OECD made certain recommendations to tax authorities in terms of, well, be reasonable and take into account the restrictions due to the pandemic. Of course, now those restrictions are being lifted, but it's a kind of application of the force majeure principle, which is something that lawyers really like. Those were my comments. Go ahead.
Good. All right, Pete, do we need to wrap up here?
Yeah, we're getting pretty close, Dale. If you want to have a couple final remarks, that'd be fine.
Okay. Nicole, you had indicated that you were interested in Elisa's question about the employer of record. Could the employer, could the de facto employer be deemed the real employer? And the answer is yes, that's a risk. But if you're handling it correctly with the help of the third party advisor, you can minimize that. But I don't think that can completely be eliminated. Do you agree?
I completely agree. That's right. And any employer of record that tells you there's absolutely no risk, maybe look into them a little bit more.
As I tell my clients, if you want absolutely no risk, go live in a house made out of Nerf and never leave the house. Our last question was, what is the simplest and least risky model to employ or contract the services of an individual for a bespoke, or as we would say in the US, customized role, while allowing them to work remotely from any jurisdiction around the world? And I think our panel has answered that if it's a short-term traveling and you're working for a few days in a hotel room, in real world terms, nobody's going to worry about that. If you're going to be in places for a longer period, there really is no one-size-fits-all arrangement that allows people to just be nomads and go country to country without thinking about some of these local issues. So Walter and Chris, I'll let you comment if you have anything different to add. Otherwise, Pete will let you
I think that's no, I think that's exactly right. As with many things in life, if you make assumptions about tax, they're usually wrong. So just always double check.
Yeah. All right.
Yeah, I agree with that. And as you were saying, Dale, there are many situations that in theory might create a risk or a tax consequence, but in practice, nobody cares about that. And there's a kind of, from a practice perspective, you can live with that.
Right. Good. That's good advice. Okay, Pete, with that, we'll let you wrap it up.
Thanks, Dale. Wonderful, folks. And again, for our listening audience, this is the kind of program you get from the ELA. We've gathered world experts together, and I want to thank them today for their contribution. Feel free to contact any of them for future updates. You can reach out to them with their contact information and bios, which is on the webinar landing page. We've been posting that in the chat box for you to get access to. If you enjoyed today's program and you want to access our next program, next week we have one on Title IX, coming back to campus, confronting the challenges of the 2020 regulations. A link to this webinar is also in your chat box during the podcast or during the webcast. For those who want to learn more about the ELA, you want to visit our podcast, which is Employment Matters. It's one of the leading HR and legal podcasts. You'll find it in the Apple Podcast Store, Google Play, Spotify, any of your favorite podcast resources. Check us out. We run programs several times a week. For those that are looking for continuing education credits, you'll find a certificate of attendance and some supporting materials, again, in that event landing page, a key place for you to find all things related to this program and others. If you'd like to listen to this program again or any of our past webinars, you'll find those on our website at ela.law. Just go to the on-demand library. If you have any questions at any time, we're always available at webinars@ela.law. Reach out to us by email there. Also, follow us on social media. You'll find us on Twitter at ELA Global and on LinkedIn under the Employment Law Alliance. This concludes our webinar for today. Thanks so much to our panelists, and thank you to our audience for participating. Have a safe day.